Ladies and gentlemen and distinguished guests, Assalamu alaikum, good afternoon. I would like to begin by thanking the organizers for giving me this opportunity to speak in front of this esteemed audience on issues which have attracted attention as far as arbitration in Qatar concerned and which are considered key concern for arbitrating parties. These issues are, first, issuing of arbitral award in Qatar, specifically developments. Second, finality of the awards. Third, process and challenges associated with the enforcement of an arbitral award in Qatar. Although arbitration in Qatar is regulated under a few provisions of the Civil and Commercial Procedure Code, due to the absence of the independent arbitration law, it has witnessed significant growth among both domestic and international users, which is evident in the increasing number of the arbitration cases conducted in Qatar, many of which international in the sense that at least one party is based outside of Qatar, as well as arbitration cases heard outside Qatar related to a transaction in Qatar, and some involving the application of Qatari law. It has nearly become a norm to include arbitration clauses in agreements concluded with Qatari companies, whether state or privately owned. As a result, foreign investors have become increasingly interested in understanding how the arbitral award is enforced locally, namely where the assets of Qatari company are most likely situated. To shed some light on the recent issues regarding issuance of arbitral awards in Qatar and the general approach of courts this regard, I will briefly refer to two well-known judgments rendered by the Qatari Court of Cassation in relation to the issuance of arbitration awards in Qatar that were subject to criticism. The first judgment was issued in Appeal Number 64, 2012, where the court denied recognition of an arbitral award on grounds of failure of arbitrators to issue the decision in the name of His Highness the Emir of Qatar. The court, in its judgment, considered this as a violation of public policy pursuant to Article 69 of the Civil Procedure Code, as well as Article 63 of the Constitution, which requires the judgment to be issued by the name of His Highness the Emir. However, quite recently, the Court of Cassation has exempt ICC arbitration awards from this formality and reversed a lower court's decision that nullified an ICC award issued in Qatar for failing to be rendered in the name of His Highness the Emir. It is understood that such exemption is also applicable to arbitration awards issued under the rules of the international institution. The second judgment was issued in Appeal Number 211, 2014, where the court set aside an arbitral award on grounds of failure by the arbitrators to include in the award the full terms of reference agreed upon the parties pursuant to Article 202 of the procedural law, which requires the arbitration award to include a copy of the arbitration document. The Court of Cassation stated in its ruling that this provision requires the arbitrators to include all terms and conditions of the arbitration agreement into their award. Therefore, it is not enough to attach a copy of the terms of reference with the award. The arbitrators need to recite the clauses of the terms of reference in their award. Moving now to the next topic of my presentation today, namely the finality of arbitral award. Under Qatari law, once the arbitration award is issued, the award creditor can seek enforcement of the award. Nevertheless, the Civil and Commercial Procedural Law provides for 3 avenues of recourses. The first type of recourse is by way of appeal. Second type is to seek the court of retry the dispute. And the third is by request of annulment. Due to time restriction, I shall only address the third avenue of the recourse, where a party may request for an award to be set aside if it does not meet the procedural requirements. According to Article 207, an award may be set aside, first, if arbitration agreement does not exist, or if it is invalid or has expired. Second, if the award exceeds the scope of arbitration agreement. Third, if the award is contrary to public order or good conduct. Fourth, if the arbitration agreement was not in writing, the dispute was not specific in the terms of reference or during the hearing, or the dispute is non-arbitrable. Fifth, the lack of capacity of the arbitrators. Sixth, the irregular appointment of the arbitrators or the absence of authorization on the arbitrator to issue the award in the absence of the other arbitrators. The request for annulment must be filed at the court of which initially competent to hear the dispute. This request suspends the enforcement of award unless the court awards otherwise. The consequences of annulment are provided in Article 209, whereby an award may be wholly or partially annulled. In either case, the court may refer the case back to the arbitrator tribunal to rectify the faults in the awards, or may settle the dispute itself. The 3 recourses allowed under the current arbitration rules to challenge the arbitration awards resulted in much criticism. But the draft arbitration law, yet to be announced, provides that the arbitral award shall be final and have the power of res judicata. Under the draft law, arbitral award may not be challenged by any means accepted by way of annulment. Further, the timeline lodged to request for annulment is 30 days from the date of serving the award of the parties. I believe that it is the need of the hour so that the new law is issued at the earliest. Now moving on to the last topic of my speech, which is requirements of enforcing arbitration award in Qatar. In this regard, we shall make a distinction between the local and foreign award as each one has different rules of enforcement. Arbitral awards are only enforceable through a writ of execution. The writ shall only be issued once the court has examined the award and the arbitration agreement and determined there is no reason to prevent the execution of the award. The requirements differ depending on whether the award was issued in Qatar or abroad. Domestic arbitration awards, which are to be enforced in Qatar, have to be lodged with the registry of the court initially competent to hear the dispute within 15 days of its issuance. To enforce an award made outside Qatar, the other party shall be notified to appear before the judge of execution of the higher civil court in compliance with the normal procedure of filing a lawsuit. An enforcement order is then granted subject to the requirements made under Article 380, which are as follows. First, the award was not rendered in violation of an exclusive jurisdiction of the Qatari courts. Second, the award was not rendered in violation of the international rules of jurisdiction of the country where it was made. Third, parties to the arbitration were notified and duly represented. Fourth, the award has the effect of final judgment in the country where it was made. Fifth, the award is not inconsistent with any provision, order, or judgment issued by Qatari courts. Sixth, the award does not contradict the public order and conducted in the state of Qatar. Seventh, the subject matter of the dispute was arbitrable under the Qatari law. As a signatory of the New York Convention, Qatar is obligated to enforce foreign awards according to the relevant articles in the Convention. However, the judiciary in Qatar considers a award issued outside Qatar or by the international institution in Qatar as a foreign award. So, if an ICC award is issued in Qatar, the award debtor may have no recourse other than opposing the enforcement of such award before the execution court pursuant to the provision of the New York Convention and recent provision under the procedural law, which results in much debate and was considered as a wrong decision, since it contradicts the prevailing international practice and the territorial standard, which treat an arbitration award as a domestic award within the country where it was issued. However, such approach by Qatari courts toward award issued by international institution in Qatar has impacted the enforcement of these awards. In order to grant an enforcement order with respect of foreign award, Qatari courts require that the applicant must submit the following documents. First, a copy of the award duly legalized by the Qatari embassy of the country where the award was issued. Second, the copy of the terms of reference duly legalized by the Qatari embassy in the country where the award was issued. Third, certificate of finality in respect of the award from the courts of the foreign jurisdiction where the award was issued. This certificate should state that the award is final and is not subject to any way of recourse under the law of the foreign jurisdiction, either because the avenues of recourses have been exhausted or the award itself is not challengeable. In recent cases, many requires of the region recognition of foreign awards have been turned down by the Qatari courts due to the failure of procuring such a certificate of finality. Under such requirement, it would be a difficult task to procure a certificate of finality as required by the Qatari court for the purpose of execution with respect to foreign awards. As most jurisdictions consider the award as foreign, where it is issued in a different country than the one in issued enforcement is sought. Hence, if an ICC award is issued in Qatar, it will be considered as a foreign award in almost all other countries. However, it will be also considered as a foreign award in Qatar. Accordingly, no country will agree to issue such a certificate of finality in respect of the ICC award issued in Qatar, as the courts of each country will deny jurisdiction because the award was issued outside of their jurisdiction. It would not be possible to procure such a certificate from the courts of Qatar, as well as account of the recent ruling of the Court of Cassation. Given the foregoing, recommend that Qatari court devotes a special treatment for the ICC and other international institutional arbitration awards, which the court regard as a foreign. The Court of Cassation has its reasons to consider these awards as foreign, which we respect. However, for the execution of these awards in Qatar, courts should facilitate the requirements for enforcement and do not require a certificate of finality. We believe that this is the only way to deal with this dilemma, particularly which the draft arbitration law seems to not having dealt with this issue. I hope I was able to shed some light on the current issues facing arbitration in Qatar. We as a practitioners look forward to issuance of the draft arbitration law of Qatar. Thank you very much.